If it pleases the court, my name is Ahmad, initial L, and I appear with my learned junior Justin, initial T, for the defendant Junior Point Eatery. Your Honour, I'll be arguing submission 1, does Junior Point Eatery owe a duty of care to the plaintiff, and submission 2.1, if Junior Point Eatery has breached its duty of care by failing to provide a security guard, whereas my junior will argue further submissions. Your Honour, submission 1, does Junior Point Eatery owe a duty of care to the plaintiff? Junior Point Eatery is a licensed cafe and occupier of the premises. The licensee is Perry Juniper. For Juniper Point Eatery to be tortiously liable for the personal injury and consequential psychological injury to Donohue, it must first owe a duty of care to him. There is no general of care imposed on a person to take positive actions for the safety of others. However, Your Honour, certain circumstances may take the general principle out of operation and the law may impose a reasonable duty to prevent harm on the part of the defendant. Your Honour, these circumstances arise where there is a foreseeable risk of harm within a criminal conduct by a third party that is attended by such a high degree of foreseeability, knowledge and predictability. Your Honour, as proven in the case of Modbury Triangle Shopping Centre versus Adzil Wagstaff, according as occupier of the premises, Juniper Point Eatery could owe a duty of care if it has foreseen the risk of harm from the criminal conduct of Stephen to Don. In addition, Your Honour, Juniper Point Eatery must fail to have known of the high degree of predictability and foreseeability of the fact such that it would require him to intervene to safeguard the injured person, as demonstrated in the case of Adele's Palace versus Mubarak. Your Honour, in submission 2.1, the Juniper Point Eatery has breached its duty of care by failing to provide a security guard. Well, in Your Honour, if a duty of care is established on the facts of the case, Mubarak, the liability of harm to patrons by third parties will depend upon whether they thought to have known the facts requiring a direct intervention that would have prevented them from the foreseeable risk of harm. Your Honour, given the nature of Juniper Point Eatery environment, the defendant could not have foreseen any danger or harm to its patrons on that Saturday. It is unless the risk was high foreseeable that the failure of providing security guards would amount to a breach of Juniper Point Eatery's duty of care. Your Honour, having a security guard on site at Juniper Point Eatery may not be necessary due to the unpredictable nature of criminal activity and how it was not foreseen. Your Honour, therefore, it is more likely than not that GP did not breach their duty of care. Your Honour, I will now pass on to my learned junior to argue the further submissions.
Perry Juniper did not breach the duty by not taking further steps to ensure the offender was off the premises following the first incident of abuse. The duty of care was satisfied when Perry escorted the disruptive trio off the premises and watched them leave in the direction of the hotel. Using precedents from the rulings found in Vary v Wong Shire Council 2005 223 CLR 422 and Wagstaff v Haslam 2007 69 NSWLR1 and Rooty Hill RSL Club Ltd and Karimi 2009 NSWCA2, we can evaluate the position the owner of Juniper Point Eatery was in with regards to the breach of duty of care when removing with the failing to remove the disruptive patrons. In order to discharge the duty of care that was owed to the victim by Perry Juniper, the three precedents mentioned above will be examined and they will prove that there in fact was no duty owed. Alternatively, they will prove that no duty was breached. Firstly, we understand from Vary and Wong Shire Council that the court must look at the facts and events of the incident in a proactive manner and not simply look at the case retrospectively. This means that the court must place itself in the position of the defendant before the incident took place to better understand the reasonable foreseeability of the risk involved with the disruptive nature of the group of the three that initiated an argument with the plaintiff, Don O'Hue. Secondly, we use the basic precedent set out in Wagstaff and Haslam. This states that the mere intoxication of patrons does not immediately create a duty of care that is owed to them by the licensee of the venue. This allows for Perry Juniper to rely on the fact that although all of the patrons were intoxicated, he still did not owe any duty of care to them. Also, he can rely on the fact that the future event of one of the patrons later returning and stabbing the plaintiff, Don O'Hue, was unforeseeable due to the lack of actual violence. To further give evidence on this, we examined that for a licensee to be in breach of a duty of care for a third party attacking the plaintiff, there must be actual and constructive knowledge of the aggressive behaviour of the attacker. This was found in the precedent set by Rooty Hill, RSL Club and Karimi. It could possibly be seen that in the heat of the moment, the mere words spoken by the attacker, quote, "I'd love to smash his face in," does not constitute for constructive knowledge that he would later return to the premises and repeatedly stab the victim. When combining the three precedents mentioned above, it can be seen that if the court is to look proactively at the facts of the case, by looking at the events from the perspective of Perry Juniper, it is unlikely that the courts will find that it was reasonably foreseeable that the attacker would return to the premises alone and stab the victim multiple times, hours after the altercation had ended. This would in fact fail the reasonable foreseeability test that is necessary to prove a breach of duty of care. It is also important to realise that the mere intoxication does not give rise to a breach of duty. Furthermore, it will now be examined that there was no breach of duty by the staff working that evening by not taking steps earlier in the night to remove the three disruptive patients, one of which returned later to stab Donna Hugh. By looking at the precedent from Packer and Torts shipping, it is found that there was no need for the staff to take any precautions. Alternatively, there was no breach of duty in the staff members working Juniper Point Eatery from failing to remove the offending persons or group from the venue. In order for this action to succeed, it has to be proven that there was a breach of the duty of care owed to the patrons by not removing the disruptive trio earlier in the night. By looking at the precedent from Packer and Torts Shipping Cruises Australia, Pty Ltd 2015, QCA 108, it is found that there was no need for the staff to take any precautions further, proving that there was no breach of duty. This can be proved by the case stating that although steps to remove patrons should be taken to ensure the safety of other guests, a licensee must be aware of the defendant acting violently in order for precautionary steps not to be taken. However, the case does also go on to say that swearing and abusive behaviour will not warrant this response within a bar, as the behaviour is commonplace. From this, it can be seen that there was in fact no obligation for the staff to remove the trio before they became violent, as they only displayed crude behaviour that is often found in bar environments. This means that it is unlikely for the court to find Perry liable for a breach of duty of care, resulting in the plaintiff later being stabbed.